a CommBeBiz webinar on IPR in the bioeconomy. Very welcome from my side. I'm Sylvia Schreiber. I'm from the media panel of the CommBeBiz project and organizing the webinars. And I'm very pleased to introduce to you today Raffaele BUOMPANE. He is Senior Advisor at the European Business Network, EBN, and a specialist in IPR, intellectual property rights, since many years. Raffaele holds degrees in economics and political sciences. He has studied at the Imperial College in London, and he has an experience of more than 20 years in the fields of intellectual property, strategic management, and public relationships. He has worked with the Italian Patent and Trademark Office as well as with the European Patent Office in Germany, and currently he is Senior Project Manager and Advisor in Brussels to the European Business Network. So before Raffaele starts his presentation, I just wanted to tell you 7 things on IPR you should know. So the first slide, please. So, did you know that IPR is a right that is held by a person or by a company to use exclusively own plans, ideas, inventions, and assets, and without a fear that a competitor will use or steal the idea? IPR include industrial property rights, copyrights, and related rights for performers. IPR grants need to be requested with an application procedure at a patent office, National Patent Office, or the European Patent Office, EPO. IPR and their development are safeguarded with the World Intellectual Property Organization, WIPO, as an agency of the United Nations, who issued an intellectual property handbook. IPR trainings are offered by WIPO, by EPO, or the EU Commission's IPR help desk. IPR intense industries are estimated to generate 70% more value added than non-IPR intense industries. And IPR in the bioeconomy saw emerge new forms, such as plant breeders' rights or protected geographical indications. And we hear more now from Raffaele BUOMPANE. Over to you, Raffaele.
Thanks. Good morning and welcome to this webinar. Thanks a lot, Sylvia, for this precise introduction of yours. As you rightly said, our conversation today will be focusing on intellectual property rights for bioeconomy and biotechnological sector. We will address these specific industrial segments while dividing the subjects in themes, in thematics. Next slide, please. Yes, as a matter of fact, here you can see I tried to identify the most important topics, the most important subjects, and I came out with these 4 proposals. So basically speaking, we start with an overview of intellectual property and bioeconomy, biotech. Then a general overview of IP, even not directly focused on bioeconomy. Then we go directly for intellectual property concerning bioeconomy. And then, last but not least, that's very important, and I will try to be as much as possible within the time constraint clear on this point, a glance on the legal framework. So, next slide, please. As you know, as we all know, so I don't have to repeat these because we are, every one of us is very conscious about the fact that bio-based economy, bioeconomy, or biotechnology refers to all economic activities which are deriving from scientific and research activities focused on biotechnology. So, differently say, understanding these mechanisms and processes at genetic, molecular level, applying then this enhanced knowledge to the creation of improvement industrial processes. So basically speaking, biologization of economy, if you want. In this slide, I wanted to point out that IP is really a key driver, one of the key drivers for all startups, small, medium enterprises, not only, but also for bigger entities, big corporations, which are really research intensive, high-tech biosector. As Silvia said before, a sector which has the highest percentage of sales and reinvested in research and development at global level. So it's very important, IP, especially because research has to be funded. So a reasonable return on investment, as you can see from this slide, for biotech companies, especially in sectors like healthcare, agriculture, and industry in general, just like mechatronic, IT, and so on, would be really a sure help for the company, for the corporation to go on having funds and go on effectively on prosperity from this point of view. So, of course, money is important. And money depends also on the assets that you have in your company. One of the most important assets is for sure what we call intangible assets, which are intellectual property assets, actually. That's the link between money and intellectual property. But of course, intellectual property needs protection, needs to be protected, and therefore we need a jurisdiction, we need a legal framework, which may be national, European, or even global. So next slide, please. Just out of curiosity, I just pointed out the short history of IP for bioeconomy, because this is maybe important to see that bioeconomy stepped into IP rather late compared to the IP itself per se. IP was born in a very rough form, if you want, even before Christ. So 500 years before Christ in Greece, we have already some examples of privacy on some discoveries. In reality, it was in England, which later on the 14th century, a formal letter patent were issued for the first time, and also in Italy in the 15th century, especially in the Republic of Florence. But here we can see directly short history of IP for bioeconomic. So the first patent, if you want, directly referring to bioeconomy, was granted in Finland on 8 November 1843. It was a yeast culture, basically, yeast culture. On 1873, Louis Pasteur patented improved yeast-making method at the French Patent Office. And then the long jump, temporal jump, we have then already in the 20th century a very, very strong interest for human body and immune system. So a lot of medicaments, basically speaking, pharma industry, stepped into strongly into IP for obtaining privacy on medicaments like insulin, for instance, erythropoietin. Here I just put some examples, but also regarding the physiology of plants. We will see that now in the next slides, please. We can refer, in fact, to some of these examples of bioeconomic solutions which have been patented, and they are referring directly coming from the observation of nature. And for instance, just to mention you some examples that I saw during I witnessed during my activity as in the European Patent Office, for instance. So, just quote you some examples: super material like graphene, biomining, so the use of iron and sulfur oxidizing microorganisms, which are used to release occluded copper, gold, uranium from minerals, from the biggest minerals conglomeration. This is especially in South Africa, Brazil, and Australia. Then biobatteries. Ehrlichia coli, for instance, is a good candidate for living biobatteries because the metabolism of these bacteria can sufficiently convert glucose into energy to produce then electricity. But there are many examples of DNA computer, that's now very much on fashion. But also, and this is something that I like very much, the biomimicry, which is basically the observation of nature and the application of solutions that nature during the evolution had applied for the solution of human living beings. We then translated, if you want, transported into industry. And here there are some examples, like Japanese train and the kingfish, the Japanese train and the kingfisher, or this Mercedes with the boxfish. Even the Esplanade Theatre in Singapore, it's inspired by a durian plant, and also the woodpecker. The woodpecker has a nice peak. So, and next slide, please. All this brings me to talk about the use of biomass, which is inversely proportional to IP. So, basically speaking, increasing value-added IP is in an inverse proportion to the biomass usage. We can make some examples here. I think this image is quite clarifying. The use of biomass, for instance, it's it's quite extended when we talk about primary industries, just like agriculture, forestry, and fishery. It goes down and increase instead the level of IP when we go towards more tech-based solution, tech-based sectors, just like IT, design, pharma, engineering, as I was mentioning to you before. So this is also explained why, historically speaking, IP came into play as an asset, as an intangible asset for companies later compared to other kind of IP titles. So that's very important to consider. If we go to the next slide, I just wanted to point out that nevertheless, biotechnology strongly needs IP, for the reason we were saying before. Here I mentioned some examples, taking into account the three sectors I mentioned to you before. So healthcare, agriculture, industry, general industry. For healthcare, for instance, drug discovery, agriculture, plant resistance, higher yields with less input, so less water, less fertilizer, so towards even a more ecologic path regarding the agriculture. So the first two are called the red biotech regarding healthcare. Agriculture is green biotech. Industry in general, instead, is white technology. In this sense, for instance, for this last area, we can have also the production of bio-based products like biofuel, for instance, bioplastics, even chemicals. And we were mentioning before enzyme or microorganism. This is exactly where it comes into play, this new technology. All these, of course, all these three areas, they strongly need patents, trademarks, registered designs, trade secrets, plant variety, domain names. Next slide, please. So it appears important at this point to browse over some of the main features and characteristics, if you want, of intellectual property. It's very important because we need to understand properly what results can be protected, or which kind of IP is on disposal for protecting these results of the research, and what this right may entail, and how long also this right may last. So here we have, on the first of two slides, we have a general general overview of the intellectual property. And I just mentioned, I will go very quickly on that, but you can check on the, of course, presentation later on with Colin, and if you have questions, you can come back to me or to Silvia or to organize on CommBeBiz. Anyway, industrial property is basically protecting invention, brand, trademarks, logos, and designs. And via patents, utility models, UM is utility models, registered trademark, or registered trade designs. These are registered rights, so industrial property. The inventor has no right until she makes a registration. The others, so the other subjects, the other stakeholders in the industry can check this because it's registered. On a second kind of intangible assets may be what we call intellectual property. So industrial property, intellectual property. In this sense, intellectual property is composed by copyright, database right, unregistered trademarks, and registered design to protect music, drama, literary artistic works, databases, reputation, goodwill, and designs. Also. These rights may be not registered, so they exist from the moment in which the work is created. The ownership, of course, it's more difficult to clarify, to assess, because we don't have a registration. This intellectual property comprises both what we're saying before, industrial property, and these other things. So basically, patents, from patents to unregistered designs, we call all these intellectual property. We have a third category of intangibles, which are the intellectual assets, which are a bit different from the first two, and they are also named as soft IP. They are just restricted covenants, confidentiality agreements to cover the issue related to know-how, trade secret, and confidential information. These are collectively known, all of them, as intellectual assets. So all three categories together, they are just intellectual assets. I think it's now time to memorize some examples, just to put you in conditions of understanding different IP rights practically applied to biotech sector. If we go on the next slide, we may have some of these examples. For instance, for patents, for trademarks, for registered design, trade secret, plant breeders or plant variety rights, and domain names. For patents, we have, for instance, here just out of my experience as in the intellectual property over the course of these years, some examples. Trademarks is quite straightforward. I think it's the one that may be understood immediately by people while talking about intellectual property. In fact, most of them, they immediately understand, which is a trademark. Whereas for designs, for instance, trade secret or patents, they sometimes working in the world of intellectual property, we have to explain better. So here you can check some of these examples in your sector. If you go on the next slide, instead, I thought it was interesting to mention for the various IP rights their main characteristics in this table. I summarized here for the type of IP, so patent, main types of IP, patents, trademarks, trade secret, and copyrights, some of the features that applies to them. So protection, applicable standards, where to apply, and duration. Each type of IP here has a more or less, you can have an idea of each type of IP, which is the protection standards and where to apply and duration. Just to take an example, we can mention the patents. For instance, the protection is on utility model, design, and patents. The standards, they have to be the research results should be new and non-obvious, of course. So should represent an advancement in the state of the art. Where to apply normally to patent and trademark office and international level. And the duration is, for patents and utility model, 20 years from the date of application. From the date of application, not from the register, from the registering date. And design patents may last even 14 years. But the same you can see also for the other the other types of IP I mentioned here. At this point, it's necessary, on the next slide, to take into account a short legal framework on biotech. I promised from the beginning I would not be I would not go very deep into this, but just for you to know, we have basically in Europe two kind of sources or legal sources for this biotech. The European Patent Convention in 1973, which was written and published for the first time came into law in 1973, but it was revised in 2000, rightly because of biotech, because there were many advancements in the biotech sector, so they needed to revise the EPC, so European Patent Convention, on the Article 52 and 53. Here, basically, there is a mention of which are the inventions that are basically patentable for biotech, and which are not, of course, excluded by the patentability, just like, you know, contrary to public order, morality, some plants and animal varieties. So you cannot, for instance, patent an elephant, which is already a living being, for instance. Biological processes, for the same reason as before. So, for instance, classical breeding, crossing, selection of animals, treatments for the human and animal bodies, and discoveries. So, just like for instance, discovering natural substances, just like this was very important, for instance, in these last years, regarding the protection, for instance, of traditional knowledge, just like, for instance, the medicines coming, natural medicines coming from plants, as a result of ages of use by some specific populations. This is not possible to, of course, to patent, but if the inventor provides, sorry, that's my. If an inventor provides the discovery, it's a description of the technical problem to solve, then it becomes patentable. All these European Patent Convention then was in a way taken into the directive, so it was reflected into this directive that I'm mentioning here, 1998, 6 July, 9844 EC. It's called also Biopatent Directive. You can find very easily if you even Google it. Here, in this EU legislation, basically there was a set of definitions, better definitions, and for the better usage in terms of ethical consideration. So the most important things, for instance, in this directive compared to the European Patent Convention is that the directive rules out, as you can see from the last line, the patenting of the entire human body. You may remember, for instance, all the polemics regarding the use of the DNA sequences and so on. If we go on, I think more or less that's a very basic short legal framework on biotech, but of course we can go more into details if needed, if you need more practical information. So the last slide, it's just a summarizing of what I was saying up to now. Quick final consideration. So economic growth and human development are proportional to society freedom to innovate. That's quite a platitude, but of course it's important to repeat. So this economic growth, of course, it's what separates developed countries and developing ones, which are not just gap in resources but in resources, I mean also in natural resources, but especially a gap in knowledge. We have many examples of small countries which are very strong intellectually, which has a very good state, economic state. So that's why this consideration is very important. More investment, of course, investments are necessary in the development of application of science, technology, and innovation, and biotech, together with other scientific sectors, it's representing assets for all European, but I think we may also say globally, so in the world, for open economic growth and human development. I think we arrived at the end of our short conversation, but if you have to add eventually some questions, or you want to write me, on the next slide you can find my contact details, and I pass back the word to my colleague Silvia, which then go on with the webinar. Thanks a lot.
Thank you very much, Raffaele, for this very interesting and rounded presentation on IPR in the bioeconomy. I have to address me now to the audience and ask if there are any questions. You have the possibility to write a question in the chat box or in your question box. If there are any questions, please pose them now. I will bridge the time meanwhile with a question I have myself. So Raffaele, you had this very interesting overview with the gradients. The more biomass in a product in the bioeconomy is, the less IPs are there. Does this also apply to biofuels? Because this is pure biomass, and I think there are some patents on biofuels varieties. Do you agree, or is this not the case? Raffaele, please.
Yes, I switch on my camera now,
Please,
so you can see me.
Yes.
Well, your question is very, I think it's very grounded. It's very much interesting, because the debate on biofuel, it's very much on the first page of the newspapers and magazines now. When you talk about biofuel, we talk about two kinds of different elements. The first one is the directly impacting on the natural environment. So in this sense, the use of biomass in the production of biofuel can be relevant in this sense. So it can be one of these exceptions on this table I presented to you before. But we have to consider that the production of biofuels is connected to the production of specific plants, just like corn, for instance. And of course, this goes into this agriculture part of the table I was mentioning to you before. So that's the first element. The second element is directly referring to the possibility of obtaining patents on biofuel. So biofuel, basically, it's a result of a series of chemical maneuvers, in inverted comma.
Processing, yeah. Chemical processing. Yeah.
Processes on some agricultural products. So in this case, intellectual property is more relevant, because of course we need to, in a way, to have a sort of biological intelligence in that. So we need to create enzymes, for instance, or bacteria which are moving kind of chemical elements from the rough product into a more elaborated product, which may be used then as a biofuel.
Mm-hmm. Okay, thank you very much. Then I also have a question about trademarks versus industrial patents. I once heard that in the bioeconomy, especially in the food sector, but also in the agri sector, the trademarks might be more important than industrial patents. Is there a relationship or a non-relationship?
Yes and no, in the sense that all intellectual property assets, what we call intangible assets, are in a way or another connected among themselves. So in a way, I'm saying this because if you have, for instance, as in your case, a a product coming from a research in the agro-food, of course, then you have intellectual assets in terms of patents, for instance. You may have intellectual property in terms of secrets, for instance, so know-how, which is protected by confidentiality agreement or other kind of what we call soft IP.
Yes, the recipe of a good salami, for instance. Recipe
but, and this is very, and coming to your point, but at the same time, for instance, trademarks are very important. Because if you have to recognize a product on the shelf of a supermarket as a, as a customer, normal customer, I need to know that this product is exactly what I want to buy. And in this sense, for instance, one of the pillars on which, one of the several pillars on which intellectual property is based, so it's built from a legal point of view, it's exactly this. So the protection of the consumers, of the, if you want, of the persons which are using products coming and protected, coming from intellectual, in a way, coming from research, and then intellectual property in terms of research, but also coming from a specific industry, specific sector, specific company, which has a specific value for the customer. So the protection of customer, the protection of person, which goes and exploit, if you want, the and buys something, has to be on the first place when you talk about intellectual property protection. So that's why trademarks is also very important, and they are strongly connected with biotech in terms of pharma, agro-food, even IT, for instance. There are many products which are strongly protected by trademarks. If I may mention, just to conclude, a typical example you were saying before, just like salami, for instance. But I can mention a lot of other examples of agro-food products which are protected, strongly protected by trademarks, which are, for instance, what we call the description of origin. So, for instance, Parmesan in Italy is protected because of the denomination which is given to it, to this product by the area of production. So this is another kind of, if you want, it's another shade of intellectual property, which is just combining the area of production with a trademark, a specific trademark.
I think this is very relevant in the food sector, denominazione originale, and also, yes, controllata, and also the geographical indications which you can register at the EU, for instance, Champagne or Camembert, Roquefort, or also Parmesano, Mortadella.
Yes.
But the interesting thing is, why is this not registered in the regional or national patent offices? Why is it run by the EU?
You can register in a national patent office, of course, the trademark. You are mentioning now a lot of products which are produced, for instance, in France or in Italy. But generally speaking, all the Mediterranean countries, they have this peculiarity. So a lot of agro-food product for direct consumption, human consumption, are protected by trademarks and the denomination of origin. This kind of protection is, from one side, run. You can ask directly your national patent office locally to register these. You may even ask European trademark, which is run by Alicante and by the office of European trademark in Alicante, UNIPO now. The former office, when I was working with them, it was called OAME, so OIM, Organization for the Harmonization of the Internal Market. Now changed the name, but it's the same office. So managing the trademark registration in Europe. But at the same time, you can have also another kind of registration, which is in Italy, actually, in Parma, which is the Office for the Protection of Product Coming, Food and Food coming from agro-food, specifically food products. So this is, for instance, another kind of protection. But of course, you may have different ways of protecting your intellectual assets. I didn't mention in my presentation because of the constraint of time, but of course you have national, European, and international path to protect your...
Yes, I think this international part is becoming more and more interesting. Also, I saw in your CV, you work with the IPR help desk in China. I mean, there are a lot of campaigns, people who are doing business with China, that there is also some counterfeiting. Is this, do the IPRs help us protect the origin of our products?
Well, yes, that's a very much debated subject, actually. The harmonization of the intellectual property all around the world, especially in gray areas, which are now, of course, more known, but they were impacting very much on the quality of products, but not only in agri-food, but in any kind of industrial sector. Just to quote you an example, spare parts for airplanes. There was a big debate on spare parts for airplanes some time ago, I remember, because of the low quality of some of these parts which had been produced out as, in a way, aftermarket way in countries which are very much mass producers. And so these implied also, in a way, a social debate because of the possibility of having accidents on planes and tragedies. But this is also valid, for instance, for some pharma products which have been also aftermarket produced, which is no good, because of course they go out from the control of the organizations, especially United Nations organization regarding the healthcare. So the World Health Organization, for instance, which set some specific standards, quality standards. So that's very relevant. That's very relevant what you said. Protection of trademark and protection of patents, protection in general, intellectual property, still has to be homogenized all over the world. But of course, compared to the past, there are many steps have been done towards a solution of these. China, just to mention China, but also I may mention India, for instance, because again, you were mentioning IPR desk China, but also IPR desk Southeast Asia. It's very relevant in this sense. Countries like Cambodia or Vietnam, they are producing, for instance, a lot of fashion products, leather, just even T-shirt, soccer or sport T-shirt, for instance, which are not, which are going out of the, if you want, a set of legal requirements. So steps have been done. We have now this IPR desk, for instance, for companies which want to go and invest in China and produce in China or Southeast Asia. We have at the same time trilateral agreements between, for instance, the European Patent Office, Japanese, United States, which are controlling also this kind of, then on a larger scale. We have a then bilateral also agreement in terms of protection. But of course, the problem is that legislation is still not homogenized. So, but you know, little by little they are going towards this direction. Also because, you know, on a global level, it is necessary to have this.
Good. I think it's very good that we have chatted at the end. I also have a last question to the audience. If there are any questions, please pose them now. I have to do some technical announcements. Also, this webinar is recorded, and it will be uploaded on YouTube and on our CommBeBiz website soon. So if you want to go through the slides, please visit our CommBeBiz website, or if you want to have the full slides and can't retrieve them from the web, please write me a mail or write a mail to our office in UK, and you will receive Raffaele's slides. It was today our last webinar in a series of this year. We will continue early next year, announce it on our website, so stay tuned, and thank you for visiting us. Thank you also to Raffaele, and see us soon. Goodbye.
My pleasure. Bye-bye.